Yesterday, I've covered quite a lot of the ground. I just want to finish going through the skeleton to make sure that we've sufficiently expanded on the remaining points. I'll finish well within the 45 minutes. I'm sorry we were a bit late, but we had difficulty getting into the court. If I could just pick up at Full Bundle, page 84, paragraph 4 of our skeleton. And just to pick up the thread, having gone through some contextual matters, paragraph 4 then just draws attention to some of the features of the actual outcome in the court below. And I had drawn your attention to the obvious fact that we've got an open judgment following the closed hearing, and that is relevant, we submit, to the degree to which any departure has been made from the open justice principle. And we point out at B that the will is not sealed indefinitely. And I mentioned on my feet as a sort of rider to paragraph B that although it's not in the bundle, CPR Rule 39(9) allows a non-party to apply to the court for a transcript of a hearing in private. So that is another option if what the Guardian is in fact concerned about is reporting on what happened. That is an option. I'm not submitting as to what would happen if that were pursued, but it is one of the...
well, I imagine you'd oppose it, Mr. Crowe.
I would clearly have to take instructions as to what our position would be, but it would be a matter for the court. All I'm saying is that these are matters within the court's power, not within our power. And there are avenues that are open. The next point, just at the top of page 85, paragraph 4C, is that the President also chose to publish a list of other royal wills and indeed to impose a 90-year sort of sunset clause, so to speak, on the sealing up. Those other wills have been sealed up until now indefinitely. The point that we make there is that the Guardian can hardly complain about the fact that the decision was taken in relation to those other wills, because the fact that royal wills have been sealed up for over a century is public knowledge and has been public knowledge for a very considerable time. The Brown judgment itself came out in 2008. You've seen reference, I think, in the papers to a succession of rulings in a case called Ben Musa, which came out.
You might think, Mr. Crowe, that if you're having a hearing about something as significant as the entire sealing of 33 wills over the last century, that is the kind of thing that there might be some benefit in asking for different views about. Isn't that sensible?
Well, Lord, the position is that the decision, in a sense, was an appendix to the decision that was taken about this will. So the President had to decide what to do about this particular will. His proposal was, against submissions made, that this particular will should be subject to an automatic review, so to speak, after a fixed period of time. And then, spontaneously, the President proposed that the same regime should be applied to the other wills as well. The point that we're trying to make in paragraph C is that it can hardly be a matter of complaint, either as a matter of open reporting or as a matter of taking other people's views on the subject, that the President chose to go further than he needed to do, even to deal with the matter in front of him. And the reason why we say it can hardly be a matter of complaint on the part of interested people, if I can use the very loose term, because the fact that wills have been being sealed up since 1910 is public knowledge. It was made public, if no later than 2008 in the Brown judgment. It then gets republished, if it needed it, in the course of the Ben Musa rulings in 2017. And the process, as I think your Lordship will be aware, both in Tristram and Coote and in Williams, Mortimer and Sunnucks, the textbooks have described this fact. So if any party had actually had a substantive basis for saying, well, one or other of these wills should have been opened more promptly than that, the opportunity has been there for years. The President actually went further spontaneously than he needed to do in an act of sort of, ultraneous transparency by imposing this cut-off. The fact that he has done so, it can't be turned round against his ruling, because he was unasked, so to speak, by any spokesperson on behalf of transparency. He was imposing a sunset clause, so to speak, and not in any way derogating from the fact that anybody can apply, if they think they have grounds, to open any one of these various wills. And again, the fact that he chose to publish a list of the wills, although he was persuaded that one could work out which ones they were, he chose to publish a list of the wills, and that again was an act of spontaneous transparency on his part, which again could have been sought by anybody until that moment, but hadn't been. So for those acts of voluntary disclosure, so to speak, and voluntary restriction on the sealing up, to be turned around and made into a source of complaint, in our submission, is simply perverse. So that's subparagraph C, and to a significant extent, it's our answer on the complaint made in relation to the President's decision to deal with the ancillary issues in relation to the other wills. And then the final point, in just going back to our skeleton in paragraph D on page 85, we've, I think, already made the point that insofar as GNM says that it's concerned about what might happen in the future, the President made clear that what the process he adopted was not going to be binding in relation to any future decisions to seal up the will. The next section of our skeleton, I don't really need to dwell on it. It's a sort of general response to the general submissions in relation to open justice, and I think you've already got our points in relation to that. Of course, we recognise the importance of the principle of open justice, but we submit that its demands are not uniform in all cases, and we submit that the President plainly did not overlook it. His attention was specifically drawn to it in the passage of the skeleton which I drew your attention to yesterday, and the fact that he himself indicated that CPR 39.2, which embodies exactly that principle, was relevant, is a further indication that he plainly didn't ignore it. He took it fully into account, and since his decision ultimately was a balancing exercise, this court, as we say, has to be satisfied that he was wrong in order to overturn it. We then turn on, just to go through the three grounds of appeal, and I've covered a substantial amount of this already, but just to recap where we've got, under ground one, our principal argument there is that the guardian can only succeed, GNM can only succeed here as a separate ground if it establishes that there is an actual right to prior notice of any proposed decision to conduct a substantive hearing in private, and in our submission the case law simply doesn't show that, and Millennium Friend referred to the BBC case. I wasn't going to turn it up again, but if you're familiar with it, I'm sure, but if you read again 66 and 67, it makes it perfectly clear there isn't a uniform right to prior notice. And and then over the page, just to make sure we've collected and identified the points over the page, paragraphs 18, 19, 20, 21, we say that there's the secondary point. Even if it were right that there is, even if it were correct that there is some legal right, that would beg the question as to who has that right vested in them and how it can be exercised. We make the submission that in a sense, it's a tail end point on the previous one, that there isn't any prior right vested in any media organisation unless it is an organisation against which a specific order is being sought, which was not this case. And the secondary point we make in paragraph 21 about mechanics, if it is being suggested that there is some right, how on earth would it be exercised? And that feeds one into the argument I was running yesterday, that in relation to this case, if it were to be suggested that the court should have invited representations from the press, the only way of achieving that would have been to give a general announcement by one means or another, whether in the alerts service, if they would have accepted it, or by listing the case by name, or by writing spontaneously to various media entities, but if so, which ones? The court would have been causing exactly the damage to the rights of privacy and the injury to the public interest in relation to the dignity of the Crown that the court was seeking to avoid. So the very mechanism itself in relation to any such asserted right would have, the operation of such a mechanism would have defeated the very purpose which the judge was seeking to pursue. Moving on then over the page to ground 2. Again, we've substantially addressed this, but just to put it in order.
I mean, do you say, Mr. Crowe, that there is no way by which the grounds on which the judge wished to maintain the dignity of the sovereign and the privacy of the affairs of the royal family could be maintained at a lesser level than complete privacy and failure to list? Now, I can see, speaking only for myself, I can perfectly see that if you publish a list saying we're having a big case about Prince Philip's will, inevitably that would start the ball rolling. I spoke about it as a floodgate yesterday. I can completely see that. But would it not have been possible to, for example, contact the Press Association and say who in these courts are taken to be representative of the press, in confidence, and say, we're having a very secret hearing, we want undertakings, we won't tell you anything about it unless you give those undertakings, if you want to attend with a view to, as I said yesterday, with a view to reporting only when the judgment is publicised, would that open the floodgates? That's my question.
Well, my Lord, two aspects to the response. The first is that viewing retrospectively, if one wants to try constructing alternatives, I suppose hypothetically one could put out an announcement saying the court is contemplating hearing something in private, but we're not going to tell you what, and can't tell you what. Yes, I'm going to come up with some...
I'm talking about something more specific, Mr. Crowe, and that is that there is a relationship between these courts and the Press Association, who go round every day, as we know, and come into court for a little while, often a very short little while, and realise it's all very boring and go out again. Now, one could have gone to them as the representative of the press and said, we want undertakings that you won't disclose the name of the case to anybody until we've agreed what the procedure is, but you may want to come into court 36 or whatever it is and hear the proposal by the judge. Now, would that open the floodgates? I mean, it seems to me that, I mean, I can see that it might, but I can also see the argument that says it might not.
My Lord, there are I suppose, three possible outcomes for if one were to adopt that process. One is it might have worked beautifully. One is it could have opened the floodgates. and one is that it might not have worked at all, because nobody would turn up to giving an undertaking not to disclose something about which they don't even know what they're undertaking about. So it might have been inoperable, it might have worked beautifully, or it might have opened the floodgates. Now, that being the position, now looking back from this court, that then leads you to have to take a decision as to whether the President was wrong not to adopt that procedure. One can certainly, as I say, one could come up with some sort of hypothetical, we would submit rather clunky, unlikely to work alternatives. But the question for this court, when a decision has been taken on an informed basis, with the benefit of submissions being made by the constitutional spokesperson for the public interest, once the President has struck a balance, the question in this court is not, could you think, if you were sitting at first instance, of some alternative mechanism?
We get that, Mr. Crowe. I mean,
Okay.
we don't need that repeated. But what I'm really asking is the vice in what the judge did, which could be said, and indeed Ms. Gallagher says it just in these terms, is that the hearing was secret and not subject to any scrutiny. Now, I know you've got your transcript point, but I think it's just a cumbersome way of achieving the same thing, and we'd have the same argument later instead of earlier. So why, I mean, really what I'm asking is, was it not an error of law to completely deny access to the hearing when there are established mechanisms, particularly within the family division, for doing so in a confidential way, and you get over that hurdle of what I mean, Ms. Gallagher might call secret justice, or what her clients might in the newspapers call secret justice, and you can still preserve the dignity of the sovereign and the privacy of the royal family. Now, I'm not saying you can, but I'm concerned enough to want some considered submissions as to whether that is possible or just too risky.
Well, our submission, and I think, I apologise in advance if this is repetition, but to try and sort of encapsulate and enumerate the points. Your Lordship said there are established procedures. There isn't an established procedure of which I am aware for advertising the fact that the court is contemplating having a private hearing in relation to an entirely unnamed case for unnamed reasons. So there isn't a procedure established which it would have been right for this judge to adopt. If there isn't an established procedure, the judge had to decide what to do. He had to kind of make it up as he went along. And he decided what to do, which brings me on to the test which I have laboured and you don't need repeated. The third point is that all of this has to be judged in the context of the point that the Attorney General was specifically joined in order to represent her considered view of the public interest. Now, it happens that the attorney agreed with us. But that doesn't mean that the public interest in open justice wasn't addressed. It happens to mean that there was unanimity about what the demands of open justice actually required in the circumstances of this case. And so where my learned friend Skeleton says that the court only heard from one side, or only heard argument on the one side, in our submission, that's actually a misrepresentation. Because the court heard argument from the spokesperson for protecting the public interest. And the fact that that spokesperson reached the conclusion he, as he then was, did, in our submission, strongly supports our position. It shouldn't be viewed as somehow being a point against us, that the protector of the public interest agreed with the outcome and the procedure that we were urging. So, Lord, I fully recognise that if, which I think is how your Lordship started, there was an error of law in not adopting an alternative route, but then yes, there was an error of law. But for the reasons I've outlined, there wasn't, and all of it has to be considered in the context of all the points that I opened with, including the fact that the extent to which open justice has been undermined in our submission is very heavily mitigated by the public judgment.
I sat with the president of the family division, a case called MN against OP, which was a case in which there were difficulties in relation to the injunctions alert service and obtaining irrevocable undertakings from those who wanted to know the names of the parties in that particular case. And that illustrates, it seems to me, some of the difficulties that there can be in devising a mechanism and operating a mechanism which produces confidentiality of the sort the Master of the Rolls is proposing, that binds, as it were, prospectively. Because I think I would be surprised. I'm always surprised by what happens with events, but I would be surprised if parties were prepared, as it were, in advance, when they didn't know anything about a case, particularly media, go against the grain, I think, for them to agree in advance to keep secret something about which they do nothing, and to do so irrevocably on the basis that if the decision, whatever it was, went against what their submissions might be, they would be bound forever afterwards.
Well, I'm grateful for that. And one sees something of the same in the facts that then led up to the various claimants case, because in that situation, what had happened was that the claimants who didn't want to be named did try going through the alerts service, and the alert service refused to advertise, to distribute, on the grounds that they said they could only do it in relation to named parties. Now, Mr. Justice Micklem said he thought that he hoped that was an error on their part, but it just again illustrates the fact that there is no established workable procedure, which it can be said that this president.
Well, is there another point? If my lady's right that the press wouldn't be in the business of giving unconditional, open-ended undertakings, and you call them in and say, I'm telling you this in secret, you can't even tell them the name, namely Prince Philip's will, because you've got the floodgates will otherwise open. So the problem is that you effectively, I think you gave me three answers. You said it either works or it doesn't work, or it opens the floodgates. But effectively, it's inevitable unless you have some very compliant process and some very compliant media representatives, which there's no evidence there really are. And as my lady says, it's incredibly unlikely. I mean, she knows more about it than any of us. It's incredibly unlikely that they're going to say, no, I'm going to bind myself for good and all. Even if you say, well, you're going to be able to publish this in due course.
Yeah.
Because they won't know what they're going to be publishing in due course.
Exactly.
So once they know, I mean, I'm arguing against my previous point, but once you know the name, that's enough and the gates are open.
And I'm grateful for all of those observations. What they serve to do collectively is to illustrate essentially the main point that we wish to put in front of this appellate court, which is that there wasn't a right thing in law which the president ought to have done, which he didn't. Yes, you can hypothetically come up with slightly clunky alternatives. He might have tried. You, with respect as an appellate court, can't say he was wrong not to have done those things.
I know you liked that point, Mr. Craig, but what I think about it is that it's fine, just provided it's not wrong and it's not falsified by the fact that the push towards open justice ought to require more to have been done. And if you read carefully what Lord Reed said, and I have, you see that he is saying at some point you really must make sure you give the press an opportunity, and it doesn't have to be before. And So this is why I'm afraid I'm sort of exploring it in such depth, because I expressed the concern yesterday morning, and I still have a residual concern, although I understand where you're coming from. But I'll now shut up.
No. Well, I'm grateful. It's absolutely right that the emphasis has always been placed on giving an opportunity for media representatives, either before or after. And that is why I do keep banging on about the opportunities to apply for the transcripts. That gives you the opportunity to make submissions after the event.
Mr. Crowe, I think you'll be less grateful for my observations. You've quite rightly been saying, let's look at what the judge did, and we've got to be satisfied it's wrong, not substitute what we thought. Everyone said that a lot, and I think we all understand that's our role, right? So can I look at what actually happened in this case for a moment, please, which would assist me? We've got a chronology that tells us that the Prince Philip executed his will back in 2013, and as we know, he died in April of 2021. We're then told that there's a date unknown when those instructing you applied for an order sealing up the will. We haven't got a date for that. I'm looking at page 33 of the conclusion.
Yeah.
All right, we haven't got a date for that, and I'm not making any criticism of that, I'm just saying we don't. But what we know is that between then and the hearing on the 28th of July, a number of things happened which aren't recorded either by date, as far as I know, order, happened. First of all, someone, either the court of its own motion, the president of his own motion, or Farrers on a perfectly proper correspondence or connection with the court, said, well, we really need the attorney in. And the judge presumably either he said, let's join the attorney, or invite the attorney to attend, or Farrers asked him. It doesn't really matter, but we know the attorney came in to represent as public guardian. So that was all good. So at the moment, this is all behind the scenes. I've not seen an order, and I presume, and if there had been a specific order made for the attorney, that would have been in the bundle.
Yeah.
So presumably it wasn't. It was done informally in some way or another.
I think I can help. Just I don't want to interrupt, but at tab 8, page
Yes.
40,
Yes.
is the order that the president made, and you'll see it's got a claim number. And you'll see that the very first recital does in fact give the date, that the chronology for some reason doesn't. It says, upon the application by the claimant by summons, dated 8th July.
Lovely, thank
So
you.
there is an originating
Lovely.
summons
Fine. And
in that claim number with the attorney as
Yes.
the defendant.
Right.
So he was joined as
Excellent.
the party
Thank
to the
you.
summons.
So we then have the two skeleton arguments that were filed, each of which is dated the 26th of July, so 2 days before the hearing, about Miss Gallagher's vociferous in her complaints about the level of redaction. I know you're looking at the clock, but I'm getting there. So both of those skeleton arguments, so far as I can tell, certainly yours, I think, Mr. Crowe, unless you correct me behind the redactions, are addressed exclusively to the issue of privacy and not the substantive.
Correct. That was the direction the president gave.
And as I think that was the skeleton argument of the attorney. All right? So when that case was, when you went before the president, you and the attorney, its skeleton arguments had been submitted, as I understand it, only in relation to the issue of privacy.
No.
Was there an additional skeleton argument by each of you which dealt with the substantive issues?
These skeleton arguments dealt with both issues. The redactions are covering up the submissions that were made in relation to the substance of whether the will should be sealed. The direction that the president gave was that GNM should have copies of the skeletons revealing only the submissions that were made to persuade the judge to hear
It's
the
just
matter
that-
in
that
private.
Looking in particular at your skeleton with the, even with redactions, it seems to be substantially addressing the issue of privacy.
It is substantially, but I mean, if one just looks at the very first page,
Your little a is missing, which presumably is seal the will, please, Judge.
it wouldn't be a difficult inference to draw.
All right. So, but my point is this. So the first topic that was to be addressed at this private hearing, which had not been listed, so completely protected, as you would say, to protect Her Majesty's dignity and all the issues that we're very familiar with now, was what should happen vis-a-vis publicity and privacy. So it would have been possible, would it not, if the judge had chosen for him to say, as he did when sitting as a Court of Appeal judge in Poppy Worthington, we're going to have to move away from the default position of open justice in this case for the reasons you and the attorney have outlined, but I think there should be a controlled degree of privacy. And what he could have done would have been to have made orders which would have permitted the press, would have required an adjournment, would have permitted the press to attend at a future hearing, private, but with restrictions on the way the matter was to be reported, as happened in Poppy Worthington and various other cases. And certainly in my experience in the family division, there have been occasions where effectively with the list goes the judge's order as to how publicity is to be managed. So what would have then happened is not that the concern raised by my lord, the master of the rolls, that half the media and every legal blogger would turn up clamouring to come in, but everyone would be very clear that the hearing as to the substantive issue, which of course was a matter of pure law and was not going to invade the privacy of the Duke's testamentary dispositions in any way, could have come, could have listened, and subsequently reported once judgment was handed down. Now, help me to understand why that A, wouldn't have been practical, and B, would not have represented a lesser interference.
Well, there are, as I understand it, two challenges in the appeal in front of you. The first challenge is that the President took the anterior decision that, in a sense, you've just described, without having heard from the press. He decided to hear.
Presume for a moment, sorry, because I know I know you're pressed for time, and I don't want to be unfair.
No.
But presume for a moment that that the court was with you on ground one. All right. So what we would be looking at is whether ground two, whether the judge was wrong, as it's asserted by the Guardian, in not coming up with some lesser interference. Ground two.
Right. And so far as that is concerned, the options that were, to be honest, I don't think I can do anything other than repackage and put back to the court the submissions that we've made, that the nature of the issue, that is the public interest that is being invoked by GNM, is related to reporting. The question then is the extent to which there has been an interference with that entitlement. Mm-hmm. The extent to which there has been any interference must be viewed in light of the fact that the Guardian has got the skeleton arguments that addressed that question, and they have the judgment that was produced as a result of the hearing. And they have as much of an opportunity now to ask for the transcripts of the hearing as they would have done to try and persuade a judge to let them sit in during the hearing. So all that has happened, in a sense, is that there has been a sort of postponement in time at the point at which the question of whether or not they should attend can be conducted. If it is not being suggested, and it can't credibly be suggested, that any substantive submissions were going to be made as to whether or not the will should be sealed, all that has been lost is the opportunity of journalists who would have been under a reporting restriction to sit and listen to the argument, if that is what they wished to argue their right to have, whereas now they are left in the position of having ex post facto to argue to get hold of a copy of the transcript. So the only difference between what the President did and what your Ladyship has just put to me, it really goes to the question of the point of time at which the argument is held. And in our submission, that isn't a basis upon which this court should overturn a balancing decision taken in the court below.
So why is it not possible to do what my lady suggested the President did in Poppy Worthington?
Why is it not possible? Well, I don't think I could suggest that it was impossible. But that, in our submission, isn't the right test. The question is whether the judge stepped outside the bounds of, however you describe it, reasonable judgment making in relation to the issues that were in front of him, endeavouring to deal with everything in one go, knowing that the argument, as I say, had been advanced by the attorney in support of that.
But there would always been contemplation of a second hearing, because by the very nature of the fact that you were all having a filed substantial skeleton argument about hearing it in private, so it would have been in the contemplation of everyone that a second hearing might have been necessary. As I say, my lady, I can't suggest that would be an impossible outcome. No. Just to make sure I have covered the rest of the ground in our skeleton, we do submit this, if we just run through in the last 5 minutes the few points out. I'm sorry, I do apologise.
No. I'd much rather try and deal with points of concern than just have a monologue. The point at paragraph, so page 89 of the call bundle, where we're responding to ground 2, the points that we make there, the first point is it's suggested that the President didn't even consider lesser on interferences. In our submission, it is apparent from the face of the judgment he did, because he says in terms that rather than going straight into accepting the submission on whether or not the summons should be heard in private, he conducted with us, as is apparent from paragraph 35, a debate as to whether or not the press should attend the argument as to whether or not the substantive summons should be heard in private. And so that in itself is a lesser interference. And as he said in the judgment, the attorney had himself, on that occasion, submitted that he was opposed to any part of the process being conducted in public. And so it is, again, inferentially apparent from that that the President did consider the alternatives that were available. The second point, I think you probably already got this and I don't want to labour it, but GNM's second point, which we deal with in paragraph 25, is that they say the President applied the wrong test, because you'll remember that structurally the first half of the judgment is dealing with the question whether or not to seal the will, and then he introduces the decision to sit in private with the words "for the same reasons." And on the back of that, it's suggested that he was not only adopting the same factors as supporting the decision to sit in private, but also that he was applying the same test as for sealing up the will, which is a not particularly high test. In our submission, that is just a misreading of the judgment. What the judge meant, what the President meant when he said "for the same reasons," is that I am taking into account the same factors which leads to the sealing up in order to lead to the conclusion to sit in private. But the fact that he applied the necessary for the administration of justice test is apparent from the fact that he refers in terms to CPR 39 as being relevant. So in our submission, it's quite apparent from the face of the judgment that he did not apply the wrong test. And we point out, although we haven't included the authorities in the authorities bundle because the principle is not in dispute, but we point out in paragraph 27 of our skeleton just over the page that unless a judge in terms says he's applying a test which you, the appellate court, think is wrong, the court should assume that he has applied the right test. And in our submission, it is not apparent that the judge applied the wrong test. Indeed, it is clear from paragraphs 63 and 64 that he did apply the correct test necessary for the administration of justice. And then the third point under this heading is the G&M argument that even if the judge applied the right test, he reached the wrong conclusion, and that in our submission bumps up against the appellate test, which I have emphasised, I think, enough already. The only other point, just worth perhaps pausing over, on page 92 of our of the bundle, there's at paragraph 29D, we touch on the authorities which Milena Friend had mentioned herself as to whether or not there is a jurisdictional basis outside family cases for admitting journalists to a private hearing. Is there a jurisdictional basis for effectively treating representatives of the media differently from the public? And you'll see that a number of cases have been mentioned by the parties in their skeletons. I don't need to add to them, but NBN, MNB, and News Group doubted that there was a jurisdictional basis. Crook appears to assume that there was a power to do so, but doesn't actually identify the jurisdictional basis for it. And similarly, the cases Milena Friend mentioned, Incidal and Manchester City, both seem to assume that there is an ability, that the court has this power from somewhere, but none of them actually analyse or identify the jurisdictional source. And it would, if nothing else, perhaps assist to understand whether there is such a jurisdictional power, and if so, what, because it is often said that the press are there essentially as sort of the most active members of the public. They are a representative of the facts that hearings are in public. So to treat them differently from the public by admitting them to a private hearing is at least potentially a contradiction in terms. So that is a point which would certainly benefit from clarification. But the overall conclusion we would submit in relation to ground 2 is either that the President came to the right conclusion, or at least that he came to a conclusion he was entitled to reach, and that is enough. So far as ground 3 is concerned, I think we covered that sufficiently yesterday, and I didn't want to add to that. And so far as remedies are concerned, we would obviously submit that you don't get there, because the judgment below doesn't fall to be overturned. But if you do consider that the President made an error, then you would obviously have to decide what to do about it, whether declaratory relief would be appropriate. And for the reasons that I expanded upon, I don't need to repeat now, but the decision that was taken was driven by the President's concern not to create exactly the media storm that he was concerned to avoid. Unless this court is able to say that the President's concerns on those grounds was wrong, then his decision actually flows from his decision to hear in private flows from the decision in relation to sealing up, in a sense. So it would be on that basis we would submit that only declaratory relief would be appropriate. Can I just turn my back briefly and see if there are any other points that we wanted to cover? I'm very grateful. Those are our submissions, unless there's anything from the court.
No, thank you very much, Mr. Crowe. Sir James.
My lord, my ladies, I would hope that after a fair bit of argument, I would have appreciated the fundamental concerns that the court has been expressing from the bench, and I will try and focus on those. But I want to try and do that, if I may, within a logical structure, and to try and place the issues and the reasoning of the judge in that structure. And my submission, first of all, is that that structure starts with a recognition that the President applied the correct legal framework / test to determine the procedural issues. In other words, whether the substantive hearing to seal up the will should be private and whether the application for that private hearing should itself be private. I put it that way because the President self-evidently and correctly directed himself by reference to the bespoke provisions in the CPR dealing with private hearings. He did so analogically, but they're nevertheless bespoke because they deal with precisely the issue that he was considering. And we note, as the President noted, the features of Rule 39.2.3. It is evidently premised on the idea that private hearings are a seriously exceptional beast, which no doubt underpins lots of the court's concerns and thinking in this appeal. But the very premise for that rule is that private hearings are exceptional, and it is so premised having regard to the general and high importance of the open justice principle. That is why the rule sets out narrow and specific circumstances in which a court might make such an order. They're preconditions to the ultimate test that then follows, the overarching test, which is that a private hearing is, quote, necessary to secure the proper administration of justice. But the other feature of 39.2, which the court will have well in mind, is that the existence of that rule, and indeed its structure, also indicates that the principle of open justice, important as it is not immutable. That's why it makes provisions of the kind that it does. And on this core point, therefore, what was the test? What was the analytical framework within which the issues that confronted the President have to be considered? There was no error. There are two suggestions made by the appellant as to basic error on that front. But the first of them, my learned friend Mr. Crowe has just dealt with, and we respectfully agree with the submissions that he made. The submission made by the Guardian is that the President applied a test of whether the public hearings were, quote, undesirable or inappropriate. That was not pursued orally by my learned friend Miss Gallagher, and that is perhaps unsurprising because the President plainly did not apply that approach or that test. The language in question which she relies upon is taken from the non-contentious probate rules and is in effect the test that governs the opening up or the sealing of the will. It was not transposed by the President into the procedural issues, and that is perfectly clear from the totality of the judgment, including in particular paragraphs 30 and 63 of the judgment, in which he makes entirely clear that the test he's actually applying is the correct one in 39.2. Identify one of the circumstances set out in 39.2 and then apply necessary to secure the proper administration of justice. The second ground on which basic error is asserted by the Guardian is that it said that the President should have applied a test of, quote, wholly exceptional. So far as that is concerned, our short submission is that the test properly applied is that set out in 39.2, introducing the concept or the adverb of wholly doesn't take one very far when the rule itself sets out the nature of the test, and it includes necessity. So it's really an assertion without any significance, we respectfully submit. So once those two have been swept away, we're left with the basic and core proposition and starting point, which is that the President applied the right analytical framework to the issue that confronted him. What that means for the purpose of this appeal, and I know you're bored with this point, but what it means for the purpose of this appeal is that one is dealing with a challenge to the judge's conclusions about the application of that test. and his evaluation, therefore, of the various factors that he is specifically enjoined by that rule to take into account, and or a challenge to the balance between them and his approach to the balance between them in the particular circumstances and in the particular context under consideration. And that is a much harder target for an appellant. And that is because at that stage, the appellant does have to show that the factors and the balances and his approach to those matters was wrong. And you've seen in the various authorities, my learned friend Mr. Crowe took you through yesterday, how that set of principles and how that basic appellate court test of wrongness is to be approached and applied, and I've no intention of going back on those cases, which will be very familiar to you. So that's the first and starting point. The second broad submission we make within this framework is that the President did correctly identify and consider the factors that bore on the context he was considering. What in effect that ended up requiring him to do was to consider and balance within the analytical framework of 39.2 the impact of public hearings or a succession of public hearings on the interests of the sovereign, both private and public, and to set them in the scales, in effect, against the weight and importance of the open justice principle and of the private interests on the other side, including the interests of the media. On the side of privacy, just to start with that, the President concluded that both the public and the private interests involved in the present context were of very significant weight indeed and favoured private hearings and all things that would protect that. My Lord the Master of the Rolls has, we respectfully submit, correctly analysed the two core features that sit on that side of the scales. First, the evident and proper concern of the President was that there was a need to preserve, as he put it, the dignity of the sovereign, judgment paragraph 64, and indeed, as part of that, to preserve the dignity of close members of her family, including, very obviously, her consort, Prince Philip. But he also noted that that need to preserve the dignity of the sovereign sounded powerfully not as a private interest purely, but as a public interest. And he carefully and correctly analysed the nature of that interest at paragraphs 42 and 43 of the judgment, and especially, if I may recommend this paragraph to the court without going back to it, paragraph 55, in which he pointed to the public interest in protecting the dignity of the sovereign and close members of her family, quote, in order to preserve their position and fulfil their constitutional role. And as part of that package of public and private interests, the judge concluded that the interests involved and the features of the case that I've just described gave it a, as he put it, a unique status, calling especially for caution and protection to ensure that their dignity was preserved with all the public interest in that preservation. But secondly, the President was also concerned, again entirely properly we submit, that there was in this particular context a clear need to protect the privacy surrounding genuinely private matters. That's how he put it in paragraph 64. That also shaded between privacy and private interest and public interest. That's the point he makes at paragraph 56. But there is also a more general concern about the content of a person's will and the details of their estate being especially and obviously private matters. And the private privacy aspect of this, if you will, was given a really heightened significance here, given the level of press interest in all things royal, if I can put it that way, without using any adjective that my learned friend Miss Gallagher might object to. Both of those factors, it is to be borne in mind, the President concluded, were being considered in a very pointed context, given that the death of Prince Philip was very recent. It had occurred on the 9th of April 2021, and the hearing was a matter of a few months afterwards. So those were the two core features on the privacy side, and just to build from them 4 short points, if I may. Firstly, those features of this context made, in the President's view, the context either close to or at the point of being unique. This was not some ordinary piece of contentious litigation. Secondly, the 2 features that I've identified and the weight that the President properly accorded to them are not challenged to any significant extent on this appeal. It is not said that they were irrelevant factors to be taken into account. It is not said that the President was wrong to attribute very significant weight to those factors. Nor is there any challenge to the concern which in effect underpins them both. It is self-evident, once the application is out there, that there will be a media storm, that applications would then ensue, that there would be a succession of points taken by representatives of the press and no doubt others, that there would be a need to resolve contested litigation at that stage. The litigation bandwagon, in short, would roll and would be inevitable. That was evidently the conclusion of the President. And all of that undermines the 2 core and key interests that sat on this side of the scale. That was, in essence, the judge's reasoning, and we respectfully submit that he was entitled so to conclude. Thirdly, both of those concerns that I've identified and the President relied upon are intimately linked to questions about whether or not the will should in fact be sealed up. They are, in essence, the interests being protected, public and private, by the sealing up. But they also underpin, as factors, the procedural issues that the President was considering. There is very, very substantial overlap between them. Indeed, the core factors are common, as between, if you want to use the language of stages that my learned friend Miss Gallagher used, the core factors are common between the stages, and the President evidently so considered them. One only has to go to the beginning words that my learned friend Mr. Crowe just drew attention to at the outset of paragraph 63, essentially for the same reasons, etc., when you get to the procedural issues. That's the third point. The fourth point that follows is that it is, we respectfully agree, I think, with the President who made this observation. It is one thing for the press to say, we want to have an observer role. It is quite another to say, we want to apply to intervene, to make submissions on unsealing, to challenge the documents that we've been given, and everything else. All the more so if the logic on which they are so applying applies or would apply equally to lots of others. Different aspects, different members of the press, different members of the public, taking slightly different positions or more extreme positions or less extreme positions, and there's no limiting principle suggested. And the reason that it is one thing to say I want an observer role and quite another to say I want active participation in the present context, which is no doubt why the court had it in mind and asked the question, is because the moment you are into broader participation, the judge's reliance upon those factors and the litigation bandwagon that underpin them and risk undermining them are put up in the brightest possible light. That's the left-hand side of the balance, if you will, the virtuous side of the balance. But on the other side of the balance, you've got the factors that favoured an open hearing to some degree or other. And again, my basic submission is that the President considered with care the factors that might bear in this particular context in favour of an open hearing. You've seen from the judgment what his initial inclination was. And again, the core submission is that he properly identified those features and did not go wrong in either identifying the factors that mattered or in weighing them. again, if I may, on this side of the balance, 4 short points. Firstly, the President was well aware, unsurprisingly, of the importance of the principle of open justice, and was well aware, again unsurprisingly, of the role of the press as public watchdog. The attorney, of course, acknowledges that importance as a general principle, but it comes with a but. And the but perhaps has 2 stages. The first of them is that the importance of both of those principles, which is not controversial, is reflected in Rule 39.2. That's why 39.2 is set up as it is, with the requirement to bring yourself within one of the specific identified circumstances, and then to satisfy a test which has the concept of necessity built within it. The second point is as fundamental, which is that there is no uniform answer to the question of how those principles can or should play out in any particular context. Again, as the basic structure and existence of 39.2 clearly indicates, the right answer in any particular context does not involve just reciting open justice as a principle, because everyone acknowledges that it's subject to exceptions. The question is, when should the exceptions apply? The framework is 39.2, and that involves doing exactly what the judge did, which was to balance the factors on either side of the scale and to weigh them one against the other. The principles of open justice and of the importance of the press being a public watchdog and all of that do not operate in the same way in all contexts. They are not uniform, and they are not the answer. They are a factor to be weighed. That's the first point. The second point is that my learned friend Miss Gallagher says that fairness to the Guardian is a factor in favour of a public hearing. They do, we respectfully submit, seek to present this either as a right or as something which must be afforded as a requirement, as my learned friend kept putting it, unless, for example, a very narrow set of exceptions such as time constraints apply. They do so on the basis that their Article 10 rights were in play, and they do so in reliance, of course, on paragraphs 66 and 67 of Lord Reed in A and the BBC. In answer to that submission, the first point that we make is that the President was self-evidently very well aware that press interests were involved. That is why he analysed them with the care that he did, and I'm going to come back to that as my third point. But more fundamentally, we submit that it is clear that in a context such as this, and generally in relation to the operation of Rule 39.2 and its application to any particular context, there is no right in the press to be present or to make submissions on all applications for hearings to be held in private. The structure of 39.2 is itself inconsistent with that, see by way of example 39.2 sub 5. But as importantly, this submission, that there is a right or there is a requirement, which is no different from saying there's an obligation, and if there is an obligation, if I remember my Hofeld correctly, there is a corresponding interrelative right on the other side of it. So it's just another way of my learned friend doing what she did at various points in her submissions, which is to jump from the general assertion of principle to the specific. That provides the answer here. My learned friend denies it, but the basis that she asserts for the need to afford an opportunity is that this context is a subject on which the press has a reporting interest, in a nutshell. But if that is the basis, it will apply across the board, and it will inure to the benefit of everyone in the same position. And that is, whatever name she chooses to put on it, the assertion of a general right. None of the cases establish any such thing. Lord Reed did not do so in paragraphs 66 to 67 of A and the BBC. He was self-evidently not invited in that case to set up some form of general right. That was not the issue that was being raised with him, and he did not do so. Rather, suitably, sufficient unto the day of the facts of the case before him, and perhaps predictably, given the source of paragraph 66 and 67, he used extremely careful language for the principle that he did espouse. He was dealing with the case before him. He then goes on to acknowledge that questions about when an opportunity might be afforded, he then considers that in paragraph 67. He identifies impracticality as one, but only one of the possible exceptions. That's why he uses the word usually in paragraph 67 when you get to that bit. He's not setting out some general point of principle. There's nothing there, put in a slightly different and broader way. There's nothing in paragraph 67 to preclude the careful weighing of contextual factors in the light of the privacy and public interest features that arose in this case. Indeed, it might be thought Lord Reed would be horrified if someone suggested otherwise. Nor is there anything in the judgment of Lord Justice Thomas and Mr. Justice Lloyd Jones, as he then was, as they both then were, in Binyam to establish Binyam Mohammed to establish anything like a general principle. And finally, Strasbourg self-evidently didn't do so either in the Mackay case. There's nothing to suggest that there's a general principle that covers all contexts and in effect cuts out the careful weighing in favour of the existence of something akin to a right. The Master of the Rolls asked my learned friend whether, I think Mr. Crowe, whether even if there isn't a right, something had gone wrong procedurally, slightly broader point, flowing from paragraphs 66 to 67 of Lord Reed's analysis in A and the BBC. And the answer we respectfully submit is no. If it isn't a right, which I submit it isn't for all the reasons I've given, then it is a factor. It's a factor to be weighed. And the question then is whether the judge, President, took into account open justice, the press interest, possible interference with their rights, and so on. And it's clear from his judgment that he did. And at that stage, once he takes into account the factor, and it isn't a right, then the only remaining question is whether he ascribed wrong weight to that, or cast the balance, ultimately and overall in the wrong way. And again, we would submit that his judgment is a careful refutation of that. So that's what we say about whether something has gone wrong. You either build it in as a right, or you have to acknowledge that it's a factor, and then you're back into the analysis. So that's the second point. The third point is that we do submit that the President was not wrong in considering the procedural questions to consider the true weight of the public interest in the subject matter. In other words, in the contents of the will and the issues on which the press might have interest, that bore on the procedural issues for obvious reasons. In that respect, the judge made clear findings in paragraph 59, both about public curiosity and about the essentially commercial interests of the press in a context like this. And in doing so, he distinguished those things from matters of real and true public interest in the legal sense. We're not dealing here, therefore, with litigation to do with contentious issues of real political or public moment. We are dealing instead with an intensely private matter, with a long-established convention, which he recognised, see paragraph 61 of the judgment, engaging a vital public interest, but at the stage of and in relation to the preservation of the dignity of the sovereign.
There seems to be, Sir James, a little conflict between what you've just submitted and what Miss Gallagher submitted as to the public interest. You may remember she pointed to 3 public interests.
Yes, you did. I'm coming to that.
well, if you're coming to it, that's fine. The public interest in open justice in all court contexts, with derogations only in exceptional circumstances. The public interest in the role of the monarchy on the premise that the ordinary law applies to them, they're not above the law. And the public interest in the way in which the assets of the royal family are distributed, again on the premise of a perceived lack of transparency and it all being a matter of legitimate public debate. And I just wondered what you said about those formulations.
My lord, yes. The first one simply takes one back to the test in 39.2. We're back into exceptionality. It adds nothing. I would note before I get to the second and third ones that the only thing that we had seen before my learned friend stood up and made those submissions was a much more general submission, which we took her to task on in our skeleton argument, asserting that these were fundamental matters of public interest concerning the royal family members and the sovereign in a constitutional monarchy, full stop. So the oral developments I've got to deal with. Take the next two. So far as the equal before the law one is concerned, that we respectfully submit is an entirely general point. It's untenable anyway. There are special constitutional considerations.
Sorry, why is it untenable?
It's untenable because there are special constitutional considerations that do distinguish the sovereign.
The new case that you gave us.
Well, there's a whole variety of different ways in which that works. The
But
dignity of the...
In principle,
Yeah.
it's equal before the law, but you say, surely, equal before the law equals part 39.2, and if you apply the same test to the royal family, as I think Mr. Crowe said yesterday, you might apply the same test and get different answers.
You might apply the same test and get different answers, so the law doesn't change in that respect.
I mean, the point is, it's put in a slightly, well, it's put in a I don't want to use an adjective that is pejorative, but it's put in quite a upfront way. But actually, it doesn't matter what you say. Of course, the monarchy is not above the law, but the law may be applied to them in such a way that a different outcome is obtained.
Well, that's the basic answer, but the only additional point I wanted, if I may respectfully, to factor into that is that there are well-recognised and different principles that do apply to the sovereign in a variety of different ways as a matter of constitutional law and as a matter of her constitutional position.
Yes.
You can't turn up and say, if it was a 39.2 case involving litigation against James Eadie, well, it's the dignity of James Eadie that matters, because people might howl with laughter. But you can say that in relation to the sovereign.
Well, of course, but on the other hand, as you pointed out earlier, the dignity of the sovereign point, the 2 points, the privacy of the royal family and the dignity of the sovereign, have not actually been contested as being significant factors.
Yeah. My lord, they haven't. I mean, I don't want to over-labour the point, but there are different considerations that apply to the sovereign and to members of her family.
What about the third point, which is the one about a perceived lack of transparency and the legitimacy of public debate about the assets of the royal family?
Well, my lord, that is, again, I respectfully submit, entirely untenable. There's an entirely distinct public interest, which everyone acknowledges, to do with the issues surrounding the level and the way of the sovereign grant and the way in which the sovereign grant operates. That's a genuine matter of, no doubt, public debate and a genuine matter of public interest, as is reflected in the fact that there is, in fact, an Act of Parliament which has sovereign grant in the title. And so there are public interests in that aspect, but that's not the aspect that we're dealing with. That's got nothing whatever to do either with the amount of the estate of Prince Philip or with the dispositions that he chose as a matter of intensely private concern, or with the dispositions of the assets that he held on his death.
Or do we come back to 39.2 again, where there seems to be a presumption that private financial matters may well be private?
Yes, my lord, we do. But what I'm concerned to identify here, what I'm concerned to explode here, is as it were, the elision on the basis of which my learned friend's submissions proceeded, between, on the one hand, sovereign grant, brackets, we accept public interest in sovereign grant, and on the other hand, will and amount.
Yeah, no. Yeah.
And I do respectfully submit that they are fundamentally different things. And what my learned friend has to identify is a genuine public interest in the amount of the estate and or the way in which the assets that the Duke held, that the Prince held on his death were disposed of.
Well, just saying there's a genuine public interest in transparency doesn't get you very far if you have to go back to applying an established test.
Exactly so. That's ultimately the fundamental point, but there are, as it were, more superficial distinctions that need to be drawn as well, including the one I've identified. And I'm sorry for burdening you with the Cross case. We didn't burden you with it initially, because it didn't...
Have I been burdened with it?
Well, I think it may have been sent to the court by email. Can I just explain what it is to try? You can kind of ignore it and put it in the bin if you wish. But I think the Master of the Rolls asked yesterday, are there any cases that deal with or touch on, as it were, the sovereign and money, or the sovereign's position? And the only one that immediately sprang to mind was a case I did in which, I don't remember quite what they were after, perhaps the number of light bulbs in Buckingham Palace, but they were trying under the Freedom of Information Act, or more accurately, under the equivalent environmental regulations. An application was made to try and get that sort of information from the royal household. Everyone agreed that the royal household and the sovereign needed to be treated in the same way for that purpose. And ultimately, what the court had to decide, the upper tribunal had to decide, led by Mr. Justice Charles, was whether or not the Queen was, I summarise grossly, but whether or not she was a public authority. And the answer was no, she wasn't. And she wasn't, even though she signed bills, and even though no legislation could actually formally take place without her signature, and even though she was the recipient of public money, and even though Buckingham Palace is currently run by the royal household, it might have been run by a government department, because of essentially the formal nature of the role that Her Majesty performs within our constitutional arrangement. She is not the government. And that, again, is perhaps the only significance of it, perhaps is to underscore the fact that it's not good enough simply to turn up and say she does a variety of things in the public arena. A more intensive analysis is required before you can make a public interest dart stick. I wanted to cover one final point under this third heading, which is that my learned friend Miss Gallagher's argument, she sought, as it were, to duck the need to address and confront. She did eventually go there in the manner in which my Lord the Master of the Rolls put to me the 1, 2, 3 on the public interest, but she said, well, I don't need to go there, and it's all very unfortunate that it would try and make me go there, because I really haven't seen enough to enable me to go there. And again, we respectfully do not agree that that position is a tenable one. She has had, and her clients have had, the judgment with all of the detail that it contains. She has had the judge's reasoning, including on the press aspects, the nature of their interest, the nature of the sovereign's interest, public and private. All of that is clear from the judgment, including the careful and detailed reasoning of the President. And indeed, it is pretty clear, it might be thought, that the interest in that the Guardian might have in seeking to open up the will is not actually in any shape or form dependent upon the intricacy or detail of fact. If they're going to say, as is evident from the 1, 2, 3 points on the public interest, if they're going to say, no, you should have done something different procedurally, because they have a great big public interest tending the other way, or if they're going to say you should unseal for exactly the same reasons, those points are going to be put at the level of principle. It's going to be said in a constitutional monarchy there's a frightful interest in knowing what Prince Philip's will says and what the amount of his estate is. But that just takes one straight back. You don't need the detail of what was said or the detail of the evidence given or the detail of any documentation for that purpose. So that's not a good way of, as it were, escaping from the coils of the untenability of the public interest which she asserts, or the need to identify those. And of course, if you can't identify genuine public interests, that has a serious impact on the weighting of the balance. That indeed was the view, and that indeed was the analysis of the President. The fourth point is a shorter one, which is that the inroad into the principles of open justice are in any event relatively limited. The judgment has been given in open, and under the terms of the order, it is possible for anyone, including the press, to apply to open up, to make whatever arguments they wish. And so there is an opportunity to participate. To some extent, it takes one back to Lord Reed's fundamental point in A and the BBC. I'm not circumscribing or being prescriptive about the timing, as long as there is a genuine opportunity to influence the issues if you wish to. And there is, under the terms of the order. That takes one then, just before I get to the third ground, the position of the attorney, which I can take more shortly, but that then takes one to line drawing and some of the concerns that the court has identified and put to the parties about line drawing. My fundamental and basic submission of principle in relation to line drawing is that the answer to the question where you draw the line is and should be answered by reference to the concerns that the President identified in this particular context and the weighting of those against the factors on the other side of the scales that he also took into account. And the question then is really a causative one. What will cause those issues to arise? What will cause, put it in the vernacular again, what will cause the press bandwagon to roll with all the risks that that contains for the undermining of the essential private and public interests that the judge placed such reliance upon? And on that basis, we do submit that listing, at the very least, is intensely problematic from that perspective and judged against that yardstick. Because if the vice to be avoided is media storm, that will create it. What then about reporting only? Well, the first thing to note about that is not the Guardian's position. That was flushed out yesterday. They want participation with all of the highlighting concerns that that raises. It's one thing to say that and another thing to say full participation point. On reporting only, the second point perhaps is that there is, we submit, not the same public interest that exists in relation to a press reporter actually being in the substantive hearing in this context as compared with, for example, criminal or contentious civil litigation. The context is important. The third point is that there would be real concern with reporting only in any event. How do you contain it? How do you select? How do you avoid starting the bandwagon rolling? And the fourth broad point, I'm going to come back to that third point in a second, but the fourth broad point is minimal deficit, if any real deficit, in circumstances in which there is going to be, and there was, a public judgment with the level of detail involved here, and in which the order left open future applications, but future applications, importantly, guided by the careful principled position identified by the President in his judgment. I said I'd come back to the third point. I come back to the third point in the context of the exchanges that occurred this morning, I think in answer particularly to my Lord the Master of the Rolls question to my learned friend Mr. Crowe as to whether or not there would have been any objection. Does it touch the vice? Would it have touched the vice? Could it have been more controlled if you'd invited the Press Association, for example, as a reporter that, again, we regularly see in court for short periods, as it were? Could they not have been invited to attend and then report later, subject to a restriction as well, all of that? And I think in relation to that, the broad points I've made already operate, but there is, I respectfully submit, a succession of difficulties that arise in relation to that suggestion. There would be difficulties for a court not necessarily suggesting any of these would be totally insurmountable, but there would be difficulties for the court in making that selection. Which part of the press do you pick? I can see serious objection being made to other parts being excluded and some parts being included. There will be difficulties of the kind that my lady, the President of the Queen's Bench Division, drew attention to in sorting out and all practically obtaining undertakings of the requisite kind to do with, particularly to do with whether or not the press would, brackets, they almost certainly wouldn't, give irrevocable future undertakings without knowing what the subject matter was and who the parties were. And of course that then takes one immediately into the next set of problems, which is with the risk of leakage. How do you contain it? Of course, if you can get undertakings, you have to assume that they're going to be done, but there is a serious risk that this is not going to be sensibly containable, or if it is, it will be only at a cost which the press would not be prepared to countenance. And that does then lead to the question, well, what is the deficit? I've made my point about this being a very different context in which it might be thought there isn't the same pressing degree of interest in the press being in the room when the actual argument is taking place. But there is the opportunity that my learned friend Mr. Crowe majored on this morning, and we respectfully agree with him that it's an important point. There is the opportunity for people to go back, if one's looking at the deficit, and apply to see the transcript. The significance of that is, of course, this, that this isn't just a cumbersome way of doing the same things. I think my Lord Master of the Rolls put to Mr. Crowe this morning. The significance of that opportunity, whatever the outcome may be, is that it provides, or it lances the balloon, if a balloon is being floated on this basis, it lances the balloon that says, this is a secret hearing. It's going to remain secret. True it is that the initial hearing would be private, but there's no judicial or jurisdictional vice in hearings being private. That's what Rule 39(2) provides for. And so to call it secret is simply to add a perjurative adjective where the proper one would be private. But more importantly, the significance of that provision allowing transcripts to be opened up is that the court retains control at all stages of the process. And the advantage of judging those things by reference to the transcript is because when you have the transcript, you will know, and the court will be able to judge, which bits of it might be sensitive, truly, and which bits of it wouldn't be sensitive. Because otherwise, you're going to have the Press Association in, and you're going to have to grapple with, you can't even do the 90-second button. You've got to, at the end of the private hearing, you've got to say, well, you've got to wait until the judgment comes. That's easy, that's the headline bit. But when the judgment comes, what then? What then can they report of the private hearing that didn't feature in any particular sentence of the judgment? So the advantage of that transcript ability, that is specifically provided for jolly good reason in the rules, is that it means that the court retains control over the administration of justice and is put into a better position to make the judgments that will be required. So it isn't accurate to call it a secret hearing, and it is not a forever secret hearing. That was always the problem with closed hearings before the Justice and Security Act and possibly afterwards. If you stay, you're in closed, you stay in closed. But there are provisions which enable that to be opened up afterwards if necessary. So there are very significant problems. Whatever, I'm not wrong, I mean, I entirely understand why the court is pressing this, because it's a big thing that the judge did. My answer to why he was right to do that is because it's a unique context and the interests favoured that. But I do respectfully submit that however seeming easy it might be to say, surely there's another way in which something could have been done, and one explores that through, sees all the difficulties, sees all the issues that arise, and sees all the benefits that the existing rules provide, my respectful submission is that the judge was entitled properly to treat this as quite a binary issue, but jolly nearly a binary issue, private or not, up to the point of open judgment, with the order then allowing people to come back on that side. So that's what we say about that. Very briefly, sorry I've gone a little over time, but very briefly on the role of the attorney. The attorney has, we submit, it a proper and important constitutional role, a special constitutional role, as the independent guardian of the public interest in the administration of justice. There have been different aspects of that role in play in a variety of different contexts which have come before the courts over the years. Perhaps the best and the closest description of the fact that the attorney performs the special role that she does in assisting the court on the issues of public interest is contained in two citations which you already have. The first of them is the bit from Blake that my learned friend Mr. Crowe took you to yesterday, and the second of them is the citation in the judgment of Lady Arden in Children's Investment Fund at paragraph 91, where she cited Lord Scott when he was Vice-Chancellor, in effect describing the role of the attorney as assisting the court on issues of public interest. But that assistance, bear in mind, comes from a source which is entitled to considerable respect and whose views are to be afforded considerable weight precisely because of the constitutional position which is held. So far as the vexed final sentence of paragraph 64 is concerned, we respectfully agree with what Mr. Crowe has said about that, and we've set out our understanding of that sentence in our skeleton at paragraph 35. Just by way of very brief summary, the President was not saying that the view of the attorney was determinative or conclusive vis-à-vis the court. It's clear in any fair reading of the judgment as a whole that what the President did was to afford the attorney's views significant, that's the adjective in paragraph 34, or great, that's the adjective in paragraph 53, weight to the attorney's views on the public interest. And that reasoning and those paragraphs, particularly paragraph 53, I think the Master of the Rolls pointed out that 53 sat within the substantive analysis within the judgment. But that substantive analysis, bear in mind, is then dragged into the procedural issues by the phraseology essentially for the same reasons at the beginning of paragraph 63. Secondly, the President, we submit, is saying that he was entitled to give that weight to the attorney's views on the procedural issues because they were, those procedural issues were affected by factors on which the attorney was entitled to offer a strong and particular view on the public interest, including the dignity of the sovereign and so on. And the judge was right about that. We submit that the President, on a fair reading of the whole of the judgment, was not saying more than that the attorney was uniquely well placed and entitled to offer those views, and to point to the fact that others legally, and I take that word from the final sentence, you'll recall it in para 64, that others legally had no similar role. That was because they could not speak with the constitutional and thus the recognised legal force of the attorney when offering views on the public interest. And that difference of position between the attorney on the one hand and others who might have views on the public interest on the other was a factor against needing to afford an opportunity for the press or the public to put their views on the public interest into the mix. He didn't exclude consideration of those other views, they just wouldn't have anything like the same weight of the constitutionally appropriate view offerer, here the attorney. And then finally, so far as the reference to public law is concerned, again we agree with Mr. Crowe in relation to that. I very much suspect that what the President meant, although it's always invidious to start interpreting judgments, was constitutional, the constitutional position. That would reflect the submission made and summarised at paragraph 35 of the judgment. It may well be that the judge had very squarely in mind the distinction between private issues and public issues of the kind that formed the centrepiece of Lord Wolfe's analysis in the Blake case. And that may have led to the reference to public law creeping in, or it may just be anomalous. But either way, it doesn't detract from the point and the core point here, which the judge placed central reliance on, which was that the attorney spoke on the public interest with real constitutional authority. My lord, my ladies, those are my submissions.
Thank you very much, Sir Jim. Ms. Gallagher.
Thank you, my lord and my ladies. First of all, Mr. Eady, or Sir Eady, Sir James Eady, has just said it's a big thing that the judge did. And that is a correct characterisation of what has happened here. And we do want to start by taking issue with Mr. Crowe, Queen's Counsel's description yesterday of this appeal as, quote, an utterly barren procedural appeal. Procedural fairness is a key part of natural justice. It simply is not to be dismissed in the way that it was by the Executor yesterday. Procedural fairness helps to build trust in the law and the legal system. It ensures that processes are open and transparent. It's a fundamental part of the accountability of the administration of justice and the rule of law. And it also importantly helps the public to have confidence that decisions are made in a way that is neutral and unbiased. Mr. Crowe's description of an utterly barren procedural appeal in this context could equally be applied to the landmark cases of Binyam Mohammed about excising passages in a judgment, the Guardian News and Media extradition case about access for the media to skeleton arguments and other documents so that they could follow what's being argued, and to a wide range of other circumstances. And in our submission, although you don't have this case before you in the bundle, we can of course provide it if required. The UK Supreme Court in the Osborne case, a very different context relating to prison law, described the importance of procedural fairness at common law and in a different context under the ECHR. And the reference there is 2013 UK Supreme Court 61, and it's particularly paragraphs 65 to 71, where the court described the virtues of procedurally fair decision-making, including that it's liable to result in better substantive decisions, the avoidance of a sense of injustice or sense of unfairness on those who are impacted by a decision which they've had no input into or advance notice of or any notice of, and also the importance of the rule of law. We see that at paragraph 71 from Lord Reid. And at paragraph 65, the Supreme Court also makes clear this is not a question of irrationality or whether a decision is wrong. Ultimately, it's a question for the court about procedural fairness. So we start by saying that that description of this as an utterly barren procedural appeal belittles the vital importance of the issues before you. And Sir James's description of this being a big thing is far more accurate. Also, Mr. Crowe yesterday, dealing with the appellate test, appeared to suggest that the appellate test here should necessarily be a hands-off Wednesbury type test. Was the approach adopted wrong? The court should be slow to intervene. He cited a number of authorities in the bundle in support of that. But in fact, on reviewing those authorities, it simply is not correct that those authorities support that position. Because in fact, as the authorities make clear, and a very good example of that is my Lady Justice Sharp at paragraph 42 of Al Maktoum, page 507 of the bundle, I don't ask you to turn it up, which makes clear that decisions which are wrong in principle are a separate category. And here, of course, we say there were two clear errors of law before you even turn to the balancing exercise which was conducted. First, the decisions taken which are impugned by us were procedurally unfair. And secondly, the court erred in paragraph 64, linked back to the analysis outlined in paragraph 35 by Mr. Crowe, summarised there, on the role of the Attorney General. And neither of those issues, that's our grounds 1 and 3, require a rationality or wrong test or interfering with the balancing exercise. They're just plain, simple, principal errors, errors of law. And then ground 2, the challenge to the decision which was in fact taken at the outset about the issue of a private hearing. our challenge on the basis that it's disproportionate or irrational is, of course, affected by the procedural failings, because it's a decision which was ultimately taken without input from the media, from Guardian News and Media or any other media. And those procedural errors then bled in to what was a flawed approach to the balancing test and a failure to consider least restrictive means in the way that's required by the authorities. Now, my Lord yesterday indicated that we haven't been clear enough on the question of whether it was right for weight to be given to A, dignity of the monarch, and B, privacy issues. And to be clear, we agree that they are relevant factors. So we don't dispute that they are relevant factors to be taken into account in the two decisions which we challenge here. But we say, first of all, on ground one, that the decision taken was procedurally unfair, and that's not affected by those two factors. And secondly, our arguments in relation to disproportionality and unreasonableness under ground two are that there was less restrictive ways of achieving those aims. And in any event, those two factors simply do not go to the latter part of the hearing. Now, we learned this morning from Mr. Crow's oral submissions that essentially what appears to have happened is that this was what he described as an act of spontaneous transparency by the President, where the wider procedural issues, wider issues of practice arose spontaneously at the hearing. Now, that part of the hearing is a good example of a part of the hearing which simply is not justified as continuing in a private basis on the basis of dignity of the monarch or privacy issues in relation to the royal family, because it's a wholly separate issue. And in addition to other opportunities which were lost, had there been present members of the media at a hearing which suddenly moved from being about one particular individual and one particular will, moved to these far, far broader issues, including, as my Lord put it this morning, the question of sealing of 33 wills over a century and the process which would be followed in future in relation to sealing of royal wills. That's a good example of where a less restrictive option, even had there been a basis for a more closed process earlier, might fall away at that stage. Now, it's been said on a number of occasions by both Mr. Crow and Sir James that the gravity of the departure from open justice here is essentially a de minimis one, a relatively minimal one, and that is not an argument which we accept. First, the very first hearing, the very first issue, my client lost the opportunity to make submissions about what the process should be at all, whether this should be a fully private hearing, whether it should be some alternative on that sliding scale between fully public and fully private in the exceptional way that was adopted here. It's also, we say, the wrong way round. It's hard to imagine a more severe interference with the open justice principle than the process which was adopted in this case. We're told by Mr. Crow that ultimately it's just a temporal issue, it's just a timing issue, because the Article 10 rights and open justice are protected by the production of an open judgment, a public judgment, at the end on the 16th of September. But that assumes that the Article 10 right and the open justice principle itself simply requires an open judgment and the possibility of reporting at the end. But of course, Article 10 protects far more than ultimate end product reporting. It protects news gathering. It protects the entitlement of a journalist to be present, not only to see what is ultimately said by the court, but also what is said by the parties and how it's said. It also removes the symbolic value of open justice. And the phrase was used by Sir James earlier about there being no vice, bearing in mind Rule 39, CPR Rule 39. But here, there is a core vice, which is that the principle of open justice has been undermined by what's happened. In addition, the suggestion was made as a done deal by Mr. Crow that ultimately what they can report relates to the judgment. And of course, as we've seen in multiple other cases, when journalists are present at a private hearing but with journalists present, there can be argument on an ongoing basis if there's a particular issue which has arisen, which may be newsworthy, for example, and an argument can be made as to whether or not that can be reported, whether or not it makes its way ultimately into the private judgment. Now, the suggestion of floodgates has been made repeatedly throughout this hearing. And Sir James asserted just this morning that the litigation bandwagon would roll and it would be inevitable, that essentially there would be a media scrum as soon as any step is taken, such as listing or any other form of notification. And Mr. Crow's submission yesterday was to rely on his submission summarised by the President of paragraph 32 of the judgment about the 4 separate occasions which would necessarily flow. Now that's utter conjecture and simply does not follow, because there's a whole range of mechanisms available to the court which would have allowed protection of those core interests, dignity of the monarch and privacy of the royal family, but which would enable there to be a more minimal interference with open justice. And
could you just answer one question for me?
Of course.
How do you, I mean, let's assume that you had wanted to get the press into the hearing, right, but without having multiple hearings and starting media, what should we say, getting the media wound up. How do you do that? What's the mechanism by which you do that? If you list it, you immediately start people's interest in what's going on. If you say to the Press Association, we're not going to tell you what it is, but you will be allowed to come and see something, but you must undertake that you won't ever say anything about it until we tell you you can, surely they're going to say, well, we're not giving you that undertaking.
Well, we don't accept that that follows. So it happens every single day that there are applications made for reporting restriction orders in the family division. And there's a process which is followed under Practice Direction 12I for the family proceedings, whereby notification of applications for reporting restriction orders, which often are redacted in terms of identities.
I know, Ms. Gallagher, but there is a huge difference between asking the press to come along and see another family hearing and telling them that there is something of great constitutional moment. If you were to tell them that, you'd probably give it away anyway. But telling them that it is a really serious thing, you set about guessing, you don't get the undertakings that are enforceable. I mean, how practically do you do it? I mean, I'm very receptive, as you probably notice, to how the judge might have done it differently. But at the moment, I'm personally struggling with how that works.
So, first of all, our submission is this isn't even a topic which was explored in the court below. We don't see any exploration of it in the skeletons. We don't see. There's no evidence whatsoever before this court that this issue was explored in the court below.
Well,
None. It's not evident in the judgment or in the skeletons.
You say that. I mean, the idea that the President of the Family Division, who's written a transparency review, has been delivered endless decisions on open justice in Re-C and Re-M, I can't remember all the letters. But, you know, of course he thought about it, and he said, my initial reaction was I wanted to let them in. And then he was persuaded not to. So there was, I mean, I know that he didn't consider precisely what I'm putting to you, but, or didn't apparently, he may have done. But what would you do? What is your best way of holding the ring and stopping I'm going to use the term a media circus.
So there's a number of options. The most obvious one of which is following the practice direction for interim non-disclosure orders, which is in tab 19, starting at page 398, and in particular at page 401, there's the indication of the right way round to approach this issue. So could I ask you to pull that up? It's paragraph 21, 22 and 23. And this reflects the requirement in case law for clear and cogent evidence to depart from the open justice principle without even giving any form of notice to media organisations. So,
which one is it in?
So it's in, apologies, my lady, it's tab 19. It starts at page 398. I wanted to draw your attention in particular to page 401.
In paragraph 22, page 401, isn't it precisely the point? It would only be in truly exceptional circumstances that failure to give a media organisation advance notice would be justified on the ground it would defeat the purpose of an interim non-disclosure. different considerations may arise with internet organisations. And then, where notice of application is to be given to a media organisation, it's going to be given to the legal advisor. But how can you do that here? What are you saying? What do you say?
My Lord, if you have a look also at page 401, there's the reference to the irrevocable written undertaking, clause 13. And these are mechanisms
13.
which are used in other contexts. It's page 407.
407. Irrevocable written undertaking.
And this is a process, and of course there would be, we anticipate, we don't know, and there was certainly no clear and cogent evidence that it would necessarily fail, below the court below, using the phrase from Lord Newberger, as this was practice guidance which he presided over in paragraph 21, but drawing also on the cases which refer to the need for clear and cogent evidence. It is, of course, possible.
The irrevocable undertaking starts with the title of the action or intended action is the Executor of Prince Phillip versus the Attorney General. I mean, that's it. The cat is out of the bag before it's signed.
My Lord, it's not accepted that this is a reason why you couldn't do this. It happens every day in the context of the family division, where there's highly sensitive cases, where the parties are not known, and where material is received by the press for legal purposes and not for publication. There are a range of mechanisms available. This is simply an option which was never given to Guardian News and Media, or indeed to others. And in our submission, the suggestion that was made by my Lady Justice King is one option, which is a mechanism for taking this matter forward, which was simply not explored, and to which the answer given by my learned friend was, and again, I don't want to use a rude adjective either, but was not persuasive, if I can put it that way. And similarly, the suggestion of using the formerly known as Copy Direct, the Injunctions Alert Service, is of course a mechanism which could be used here. And there are many examples of where undertakings have been given by journalists and by lawyers. Incidel, I'm conscious, is a case known to the panel, and there are many others. And there are many examples of a whole range of mechanisms which could be followed, which were simply not considered here. But our submission is that the practice guidance applies, and there simply is not, looking at the test, there was in this case a total failure to provide advance notice. The requirement in paragraph 21 sets out a point of principle with which we agree and we adopt in this context. A failure to provide advance notice can only be justified on clear and cogent evidence by compelling reasons. And the submissions which are captured in paragraphs 30 to 38 of the judgment are reflected in the papers before you. For the Attorney General, in the material which we've had provided to us in writing, the argument is exceptionally limited. It says simply that the Attorney General supports the proposition that for the court to sit in public in the present case would seriously risk defeating the very purpose of the claimant's application. And there's no explanation whatsoever. That's at page 7 of the supplemental bundle. There's no explanation whatsoever of there's no exploration of any alternatives to a fully public hearing in those papers, or captured in paragraphs 30 to 38, or captured in paragraphs 63 to 64, or indeed anywhere else in the judgment. This is a situation where no advance notice was given. No notice was given after the order was made on the 28th of July in sufficient time to impact on the ultimate hearing taking place. And there simply was not clear and cogent evidence or compelling reasons. And turning the onus around and asking us to set out precisely what approach should have been followed, it is in our submission not the correct approach. But the key point is that there are a range of options that lawyers for the media, whether through formerly known as Copy Direct process or another process, can be told there's a proposed private hearing in an important constitutional case, and no further details will be provided unless an undertaking is given. And then some media organisations may choose to comply with that, some media organisations may not, and I'm conscious that my Lady Justice King will have been in many cases which involve some media organisations participating on the basis of undertakings and some others not. And indeed, Poppy Worthington's been mentioned. That's a case in which some media organisations signed the undertaking, some chose not to, and it proceeded on that basis. So that's not unusual. That's a very common feature of reporting restriction orders in particular. And we've also seen the Copy Direct Service, the Injunctions Alert Service, amending and including additional categories as issues arise, like, for example, coroners' courts being added. Now, we recognise, of course, the point that's made by Lady Justice Sharp in a question to Mr. Crowe about MN and OP and some difficulties with the Injunction Service. And we saw in various claimants that there was a difficulty initially with them not understanding whether or not they could in fact serve it. But ultimately, what's said in various claimants is it's a matter for the court to regulate its own procedure. And the court said it should still be served. We consider it's necessary to serve it. And it was a matter for the court to consider below what lesser alternatives could be followed. And that's simply an exercise which they didn't engage with in the court below at all. Now, there was a suggestion in answer to, it's also, of course, possible for a reporting restriction to be made at the outset. And my lady, with your question, there's, of course, a possibility of giving an indication that a hearing's taken place and a reporting restriction order being made at that time. And that could have been a reporting restriction order which would apply in the absence of any alternative application in the meantime until publication of the judgment, for example. And there could be an application prior to that to lift it if there was a change of circumstances. Now, there was a question to Mr. Crowe regarding the issue of the jurisdictional basis for permitting the press into a hearing whilst excluding the public. And there is a clear jurisdictional basis for that. I won't turn up the cases in light of the time, but I want to give you some of the references. It is correct that in the MNB case at tab 18, my lady, Lady Justice Sharp, in that case, did doubt, because no jurisdictional basis had been suggested to you, as I understand it, my lady, to permit the court to distinguish between the media and members of the public at that time. It's tab 18, the relevant paragraph is paragraph 14, page 389, but I don't ask you to turn it up. Our submission is, the jurisdiction is the court's inherent jurisdiction to determine the requirements of open justice and how that principle should be applied. We rely, as grounding that principle, on tab 20, page 445, paragraph 69, the Guardian News and Media case. The rules, including CPR 39.2, sets out a process. They're not the source of the power. And in that case, the issue was the extent to which a court had the power to provide the Guardian with documents from the case that had been put before a judge. And the decision is clear that it's the court's inherent jurisdiction to determine the requirements of open justice and how to apply that principle. That judgment has subsequently been approved 3 times by the Supreme Court. Kennedy, Dring, and A in the BBC. You have one of those cases in the bundle, A in the BBC, tab 21, see page 466, paragraph 23, and see Lord Reed's express approval of the inherent jurisdiction at pages 466 to 7 and paragraph 27. And if you need to be assisted by also being provided with Kennedy and Dring, please do let us know and we'll give them to you. But that is beyond doubt in our submission since the Guardian News and Media case and those 3 decisions of the Supreme Court. We then have in the bundle a range of examples of that. We've got Incidal, a criminal trial essentially all heard in camera but with accredited journalists present. The Court of Appeal recognising the importance of public scrutiny that would be provided by the presence of journalists during the hearing. That's tab 22, see page 493, paragraph 41, Roman numeral 2. And there was no suggestion there that the court didn't have jurisdiction to permit the press to attend, but not the public. And another example in the bundle is Manchester City and Premier League, confidential arbitration appeal, where the court permitted a journalist to attend, notwithstanding the fact that the court was sitting in private. Again, no suggestion the court didn't have jurisdiction to permit that approach. That's tab 25, page 548, paragraphs 28 to 29. Now here, in short, on our 3 grounds which we've advanced, the answer on the procedural fairness ground 1, has been to say, unless we can show an entitlement or a right, that the ground falls. And you have our submissions on that, and what you've heard in response simply doesn't address the submissions that we made yesterday as to why procedural fairness bites. They also failed to explain why the principle which is advanced would not equally have applied in Binyam Mohammed, for example. On ground 2, in respect of the disproportionate interference and the absence of a consideration of a less restrictive means, there's a range of options which were available, which were not considered, and there was no clear and cogent evidence before the court below and compelling reasons justifying the approach which was adopted. Even if it justified the approach which was adopted in respect of considering this particular will and this particular individual, there has been no argument advanced as to why it was necessary to continue with a private hearing when considering 100 years of royal wills and the more general process. The only answer we have to that is Mr. Crowe saying, well, essentially, it was an act of spontaneous transparency that he decided to engage in this, and it just arose on the hoof at the hearing. And that's simply not a good enough reason for issues of such fundamental importance in circumstances where previous rulings have not been considered to be continued in a private hearing with all members of the press excluded. And then finally, in respect of the role of the Attorney General, you have our submissions from yesterday, and the answer from Mr. Crowe, when you read the judgment carefully, doesn't grapple with the fact that not only is there a very clear statement in paragraph 64, as you, my lord, indicated in questions, which makes clear that as a matter of law, the President understood that on the issue of private hearings, he could not hear from someone advancing an alternative view of the public interest to that advanced by the Attorney General. That's also supported by the description in paragraph 35 of the judgment of the argument which was advanced by Mr. Crowe. And we see that in the judgment. I'll give you the page reference to it. So it's paragraph 35, and it's page 52. And it says, Mr. Crowe rejected the court's suggestion that allowing lawyers acting on behalf of the media to attend and make submissions might provide a proportionate process and allow additional arguments in favour of publicity to be made. He submitted that as a matter of constitutional law, where the Attorney General represents the public interest, relying on Gurrier, it's not possible for another party or constituency also to stand for the public interest with a contrary view. Now, the other paragraphs which refer to the role of the Attorney General relate to the substantive decision, when it's quite clear that the submissions made by the Attorney General were not considered determinative. When you read paragraph 35 and you read paragraph 64, it's clear that on the two issues with which we're concerned, those two initial decisions, the view of the Attorney General was indeed considered determinative, and that was on the basis of an error of law, as encapsulated in paragraph 35 and in paragraph 64. And of course, the presence of the Attorney General, in this case, was giving one view of the public interest. It was a view of the public interest which involved the Attorney General advancing submissions regarding a prurient press with a purely commercial interest. There's no indication in the papers before you that, in fact, a submission was made about the watchdog role of the press or the wider public interest in open justice issues. And as we indicated yesterday, there's multiple cases in which the Attorney General and the media have been heard and have given alternative views. This is not a barren procedural appeal. This is a matter of fundamental importance to my client, to The Guardian, to the media in general, and to the public. And unless I can assist you further, I think that concludes my reply.
Well, thank you very much. Thank you all very much for your arguments, which we found extremely helpful. We will take time to consider our judgments. We'll hand them down in the usual way. Obviously, the embargo on the publicity of this judgment will be particularly important. So can you make sure that my clerk has the names of the people to whom it's proposed the judgment will go? They should be strictly limited. It would be most unfortunate if the judgment were to leak. And when you get the judgment, please use it only for the purposes of agreeing an order and consequential directions, if any, and costs, of course, and try to agree that order, and if you can't, we'll deal with all submissions on that question in writing. So thank you all very much.
both